Good morning, friends. Normally, according to the Article 21, right to know, which is a fundamental right, the Right to Information Act 2005 has come into existence. So, according to Section 5 of the same Act, you can ask for any information. Of course, the public authority can refuse information under Section 8 of the same Act in cases where it relates to integrity of the state or security of the nation. All these things you know very well. Here, the Honorable Delhi High Court, Justice Naveen Chawla, very recently actually sent back the file, disposed the appeal by saying that the order given by the CIC, that is Chief Information Commissioner, according to RT Act, is very cryptic order. It's not elaborate. The details are not mentioned. So a judgment should not be like that. Normally, we'll be seeing the judgments of the Supreme Court, High Court, even the Sessions Court also, where they give elaborate interpretations. They will discuss the jurisprudence, they will discuss the precedents, that is the previous case laws. All these things are there. Right from the section, we have seen so many judgments where the section of law will be rewritten in detail and discussion will be taking place. So normally we get bored on seeing all these 100 pages judgment. Normally we want to go to the point whether it was appeal was allowed or upheld, withheld, like that we want to see. But Supreme Court is not that definitely it's intellectuals. Therefore, they go to the root of the problem, they will discuss in detail and they will decide the case laws and then only come to the proper decision. That is the way of giving a judgment. Of course, CIC, the judgments normally we call them as orders. We can't call them as judgments. Anyway, so since High Court is the appellate authority over the CPIO, now in the case of SR Das versus CPIO and nodal officer, that is GAIL. CPI means Chief Public Information Officer. GAIL means Gas Authority of India Limited. So on 11/11/2020, the Honorable Justice Naveen Chawla, he has actually disapproved of the order given by the CIC. Now let us know what happened. Right, the petitioner, remember, he is SR Das. So he is also one of the bidders for GAIL. Then of course he was aggrieved by the action taken by the GAIL, and he thinks that it was not in proper order. Therefore, he filed a petition to the GAIL authorities seeking the following information. Number one, whether the lowest bidder submitted the required certificates and testimonials to meet his technical terms and conditions to achieve the qualifications criteria. If so, please provide copies of the same. So his point is very clear, whether the lowest bidder is competent or not, whether he is able to meet the requirements or not, whether he furnished the documents or not. All these things he has asked, and he asked for the copies of the same. Right? So normally they don't give information. Same according to Section 8, they refused to give information. But they stated that the lowest bidder also complied. Lowest bidder also complied with the terms and conditions. That's all. They don't want to provide him any credentials or details of the same. So the matter was taken as an appeal. In the first appeal, he has gone to the State Information Commissioner, and he has represented that he was not satisfied with the reply given by the CPIO, because they stated, according to our norms, and this fellow he is the correct bidder, he is the lowest bidder, but of course the bidding was gone to some other person, like that. Then CIC, right, of course, they have called, they have given notices also, and CIC stated that what happened is the lowest bidder, even though he is technically qualified, since the matter is open now, since the allotment was given to some other party, therefore you have to give the information. You have to give the information as required under the RTA Act. Right? So the CPIO was directed to give the required information as per the RTA Act. And once again, the reply from GAIL is that So the information provided by CPIO previously is complete and no further explanation can be given. That means already this man was the competent person, lowest bidder also qualified. That's all. Same reply they have given. Right? So no use. Even he has gone to for appeal also, no use. Ultimately he has come to the High Court. Right? Now the High Court stated that the matter should be discussed elaborately. Same reply was given once again. What is the use of the appeal? This is the point he has found out. So the updated status should be given at least to them. Or the qualifications, because it has come into the public domain, definitely the qualifications can be supplied to him. Or at least it would have been asked to come to the office and take a copy of the same. So without mentioning all these things, this order of the CIC did not discuss any of these matters in detail. Therefore, the Honorable High Court remanded the petition, the appeal, back to the CIC to dispose it to give a deliberate order and dispose the same. So now and then it becomes difficult by giving cryptic orders also. But anyway, the order should be clear, cogent, understandable, and to the point. That is what the Supreme Court and the Honorable Delhi High Court says. Thank you.